the gentleman that she knew by the street name of Detroit, who was later learned to be Rory Wilson, based on Todd O'Quinn in his initial interview gave a detailed description of the sequence of events that lined up with the Cosme video, as far as when they saw one person running, and then when the time delay for the second person running, that he was going up the hill.
Ma'am, you don't have to get into all that detail to answer the question, please.
Yes, sir, sorry.
So, but you can continue with your answer. I'm just saying that it didn't call for recitation of some of that.
Okay.
We'll move on. Your Honor. You indicated you spoke to Ms. Belmonte, correct?
Yes, sir.
Was she able to identify her attackers?
She was absolutely able to identify Detroit Rory Wilson.
And what about the second attacker?
No,
Was she sure about that?
she was absolutely positive she could not see the second person.
And based on, did you ever have a chance to speak to a person by the name of April Walker?
Yes.
And without telling me the nature of your conversation with her, based on your conversation, though, was she able to corroborate your investigation and the conclusions you had based upon that investigation?
Yes.
Judge, may I have a moment?
Yes?
One last question. Ms. Malone, based on your investigation in this case, based upon the conversations you had with other individuals that were involved in this case, did you come to a conclusion that you had enough evidence to charge this defendant with robbery and murder?
Yes, sir.
Thank you. I have no further questions.
Okay, we're going to ask if we can approach the bench here, please. In the jury room for a bit, please. Appreciate your cooperation and patience. All right, jurors are gone. Be at ease. So, you would like this witness held subject to recall. So, my question is, how are you going to communicate with her? Is there some numbers she's supposed to call, or is there some a way that she'd like you to contact her. That's my concern is, if in fact you intend to recall her, how as a practical matter is she to get word?
Your Honor, actually, at this point, I do have the MCSO is what I've been using what I used for my subpoena. I would imagine if I could get an email for Danielle Malone that way, we wouldn't have to interact in any inappropriate way.
Do you understand what's happening here?
Yes.
Okay, so in other words, the state's finished with your testimony. We've gone through the direct and the cross and the redirect. Mr. Tucker would like to have the option to recall you in his case. Okay, that's certainly within the rules, and I need to figure out a way that he can communicate with you to let you know if you're going to be called and basically when. So I'm trying to facilitate that so we don't have any confusion if the need arises. So he suggested an email, or is there a work number? How would you suggest he contact you in the event that you're going to be recalled?
My work number is manned 24/7 since it's a 911 center, so he could call at any time, and then they can reach out to me either via phone or sending a deputy to my house or whatever needs to be.
And will that work for you, Mr. Tucker?
I mean, it will, Your Honor. I just, in an overabundance of caution, to make sure that, again, there's no even illusion of impropriety. I still think an electronic message would probably be better.
Well, I'm not going to force her to give an email if she's disinclined to do so, unless it's a work email.
My work email is dmalone@keysso.net.
D with a period or not?
No period.
D
Malone, and then just at Keys, KEYSO.net.
Okay, so you've got work email and you know her work number, phone number.
No, I do not know.
It's 305-289-2351 is the non-emergency line.
Just to make sure I have it correct, 305-289-2351.
Yes, sir.
Okay, good. Thank you.
All right, so any instructions that I need to give the witness at this point, seeing that she may be recalled?
She's still going to be, she'll still be under the rules that she can't talk about it to anybody in the case, or her testimony, I think, would be a safe bet.
I would agree, Your Honor.
All right, so again, it's a little, I just want to be clear, rather be overly cautious than not. So the rule of sequestration of witnesses was invoked at the beginning of the trial. So what that means is witnesses cannot speak to anyone about their testimony. Normally it applies while they're out there waiting. They can't be in the courtroom or after they've testified until I suspend the rule as it applies to them. The exception to that is witnesses can speak to attorneys for either side and about their testimony as long as they do it one witness at a time. Now, what makes this a little bit different is she's already testified and could testify more. So it's kind of like in the middle of it, kind of. So normally at that point, nobody's really talking to witnesses unless there's some exceptions. So other than this is when we need you, I would say just don't talk to anybody about your testimony.
Yes, sir.
All right? I'm not trying, I just don't want, some confusion or some problem. That's the last thing I want.
No, absolutely. Same here.
So everyone satisfied with that instruction?
Yes, sir.
Okay. All right. All right, ma'am.
I do have, how long of a heads up would I be given? Half hour, an hour, half a day? Do we
Well,
know?
I guess that's up to Mr. Tucker, but I would hope that you'd have a day notice. I'm not saying it's required, but that's normally the case as attorneys plan their case. They have an idea of who they're going to call, about how long it's going to last, and so they're able normally to give a witness a day notice. Now,
Your Honor, I will go ahead and strive, and I will make sure that I give her a day's notice at least.
okay. So, anything else?
No, sir, I think that's it. Thank
Take care. Okay, so state didn't line up any other witnesses because of the belief that, or expectation, or thought that this was going to last a lot longer than it did.
Yes, sir, that's correct. Our apologies. We had witnesses last week that we never got to, so we thought we'd scale back, and our anticipation would be lucky to get her done this afternoon, so we didn't line any other witnesses up for today.
Okay, so what about tomorrow?
We'll have a full slate of witnesses tomorrow, Judge.
And can you give us an idea who
Of
that
course.
would be?
I'm hoping for Travis Johnson tomorrow, and hopefully the DNA analyst from FPLE. If we can get those done tomorrow, and in the abundance of caution, I could have the medical examiner here, but we anticipated him on Thursday, so we told him Thursday right now, but if I need to, I can move him up. Friday, he's not available, so it's got to be today or tomorrow or Thursday. And just one second. Wait, no, he's our next. I think those are the last three witnesses we anticipate calling, Judge.
So, as it stands right now, you'd be resting after,
Medical examiner on Thursday, I think, is realistic.
so then, Mr. Tucker, presumably, if you have witnesses you're going to call, you can kind of start to plan for Friday. If there's going to be some impeachment efforts as to Mr. Johnson in particular, to the extent that we can have those materials available and pinpointed, that would be helpful. So, presumably somewhere along the line, state's working on jury instructions.
We have them, Judge. I think we just have to tweak them a little bit. And
Tweak them. I already have a general copy, just, but I'll bring a preliminary copy tomorrow.
I'm just thinking ahead, and of course, providing the defendant with just what your proposals are at this point, realizing that we don't know for sure until we get to that point. But anything you'd like to talk about regarding scheduling before I bring in the jurors? And
No, I think we pretty much addressed it, Your Honor. If the state believes that they're going to be concluded with their case on Thursday, and I think at worst it probably goes to Friday, right? Depending on my impeachment materials or my cross-examination. Yeah, I see. We either start on Friday with the defense or we start on Monday.
I would certainly count on Friday. I just can't imagine that the three witnesses that Mr. Mansfield's identified are going to take more than 2 full days. I just can't imagine it. You know.
Two and a half, because we have half a day Thursday, so we should.
Oh,
I don't think we're going to.
well, that would be 1.5 then.
Oh yeah, I'm sorry. You're right. 1.5.
Well, okay, that's a good point.
So we might. I still anticipate finishing our case this week.
Well, I'm sure you'll keep them apprised, but to me, if you finish the medical examiner, the lab analyst and Mr. Johnson, half day each, and then a half day for the medical examiner, that doesn't seem like it's a short amount of time. That seems like it.
That's a lot of time. Half a day for a medical examiner shouldn't take that I don't think it'll take that long.
Yeah. And then, so I'd say all things being equal, we'll shoot for Friday to start the defense case, but always being flexible. So now I have the unenviable task of explaining to this jury why they were here for 45-minute session. But I'll do my best within what I can explain. So let's bring them in.
All jurors present in the court with me, Your Honor.
Thank you. Please be seated, ladies, gentlemen of the jury. Well, I have some news. Whether it's good news or bad news, that's depends upon how you want to look at it. The news is that we don't have anything more to present to you this afternoon. It's good because you get to go home. You know, this is bad because we didn't make use of much of the time today. So, however you want to look at it, I apologize. It's not the way I would prefer a trial proceed. But again, without getting into all the details, it's the reality of the situation. There's just no other witnesses available this afternoon. We can only plan so specifically, and then there's factors that are beyond anyone's control. So I apologize. I certainly don't take your time for granted. As I said, to the extent that you're freed up until 9 tomorrow, I guess that's good. To the extent that I would prefer to make use of the next 3 hours, it's not. Big picture, I did say from the very beginning this could take up to 4 weeks. That was one of the reasons I had a liberal time estimate, because I tried to factor into that assessment these variables. So always trying to stay focused on the big picture in that schedule. We're fine with that. I'm sorry for any inconvenience today, but I expect tomorrow to be a full day starting at 9 o'clock. So please adhere to the court's cautionary instructions. Have a good evening, and we'll see you tomorrow.